Donald Trump's legal nightmare, the Epstein case he filed that could destroy him. Donald Trump filed a lawsuit that might end up being the worst legal decision of his entire career. And the wild part is, nobody forced him to do it. He walked right into this one voluntarily. And what's waiting for him on the other side could expose everything he's been trying to bury about his connection to Jeffrey Epstein. This is a story about legal hubris, a mysterious birthday card, and a trap that's slowly closing shut. Let's break down exactly how this happened and why legal experts are calling this move. Well, let's just say they're not using flattering language. So here's the backdrop. The Wall Street Journal published a report about a letter that was allegedly sent by Donald Trump to Jeffrey Epstein for Epstein's 50th birthday. This wasn't just any casual happy birthday note. According to the reporting, the card contained language about enigmas, never aging, and keeping secrets. The kind of language that, given what we now know about Epstein's world, carries an extremely uncomfortable weight. The kind of language that makes people ask very pointed follow-up questions. Trump's response was immediate and predictable. He called it a total fabrication, a lie. He insisted he never sent any such letter. And then he did what Trump so often does when he feels cornered. He went on offense. He filed a defamation lawsuit against the Wall Street Journal, claiming they knowingly published false information to damage his reputation. Now pause on that for a second. Think about what that means strategically. When you're a public figure and you sue a major newspaper for defamation, you're not just making a legal claim. You're opening a door. And once that door swings open, everything on the other side becomes fair game. Every question, every document, every deposition. You invited all of it in by filing the suit. But before we get to the trap, let's talk about what happened first. A federal judge looked at Trump's initial complaint and dismissed it. Not because the judge said Trump was lying, but because, as a matter of law, Trump failed to adequately plead that the Wall Street Journal acted with what's called actual malice. This is a critical legal standard that comes from the landmark Supreme Court case, New York Times versus Sullivan. When you're a public figure suing for defamation, you can't just say they were mean to me or this made me look bad. You have to demonstrate that the publisher either knew the information was false and published it anyway, or that they acted with reckless disregard for whether it was true or false. The judge essentially said, even if I take everything in your complaint at face value, even if I accept every single allegation you've made as true, you still don't clear that bar. You haven't shown actual malice under the legal definition. Case dismissed, but here's where it gets interesting and here's where the trap starts to take shape. In our legal system, when a complaint gets dismissed for the first time, the court almost always grants what's called leave to amend. This means the plaintiff gets another shot. They can refile a revised version of their complaint that addresses whatever deficiencies the judge identified. The law says this leave should be granted liberally, meaning judges are supposed to be generous about giving plaintiffs a second chance. The reasoning behind this is actually quite sensible. Courts don't want to throw out potentially valid cases just because of a technical oversight or a poorly worded paragraph. Maybe the lawyer missed something small. Maybe the substance is there, but the form needs work. The system is designed to prioritize getting to the truth over punishing procedural mistakes. The problem is that some litigants exploit this feature of the system, and Trump is a master at it. Here's how the game works. You file your initial complaint, you drag out every deadline. You ask for extension after extension after extension. When the court finally dismisses it, you use your leave to amend to file a new version. That process takes more months, more briefing, more hearings, more delays. If you're strategic about it, you can stretch a federal lawsuit from filing to final resolution over 12 to 18 months, sometimes longer, and during all that time, you're controlling the narrative. You get to say, I have a pending lawsuit without ever actually having to prove anything. It's actually remarkably similar to certain approaches in international diplomacy. You drag things out so long that the urgency fades, people move on to other stories. The issue just sort of dissolves into background noise, and by the time there's a resolution, the world has already cycled through 100 other crises, and nobody's paying attention anymore. So Trump lost the initial round, got his leave to amend, and immediately announced he would refile. And this is precisely where the trap springs shut. Because here's what happens when Trump refiles. Let's say his lawyers do the obvious thing and add the magic words. They insert paragraphs about actual malice, They claim the Wall Street Journal fabricated the letter. They allege this was a deliberate, knowing lie designed to harm a public figure. Great. The complaint might survive a motion to dismiss this time, but surviving a motion to dismiss doesn't mean you win. It means the case moves forward, and when a case moves forward, discovery begins. And discovery is where everything falls apart for Donald Trump. The Wall Street Journal has the most basic, most powerful tool available to any defendant in a lawsuit. They can demand the plaintiff's deposition. And because Trump is the one who filed this case, because he's the plaintiff, he has absolutely zero legal basis to resist sitting for a deposition. None. You don't get to sue someone and then refuse to answer their questions about the very claims you brought. That's not how any of this works. Now think about what that deposition looks like. Trump sits down under oath, and the Wall Street Journal's attorneys get to ask him about everything related to this case. And what's this case about? A birthday card sent to Jeffrey Epstein, which means every question about Trump's relationship with Epstein is fair game. Every interaction, every phone call, every party, every flight, every statement Trump has ever made about knowing Epstein, every statement he's ever made about women and girls in Epstein's orbit. All of it becomes discoverable because all of it is, in legal terms, reasonably calculated to lead to the discovery of admissible evidence. 7 hours, that's a standard deposition. 7 hours of questions about Jeffrey Epstein under oath, on the record, with a court reporter capturing every word. And we know from past experience exactly how Trump performs in depositions. The E. Jean Carroll case deposition was a disaster for him. The depositions in the New York Attorney General's investigation were catastrophic. He contradicts himself. He makes admissions he doesn't realize he's making. He gets angry and says things his lawyers desperately wish he hadn't said. A Trump deposition is a legal landmine for Trump every single time. And it gets even worse than that. Legal analysts have pointed out something particularly devastating about Trump's own complaint. In the filing itself, there's a footnote that references a whole collection of articles that allegedly followed the Wall Street Journal's reporting, articles that made various allegations about the Trump-Epstein connection. Trump included these to try to show damages, to demonstrate how the original report spawned additional negative coverage. But what he actually did was hand his opponents a roadmap for deposition questions. The Wall Street Journal's lawyers can literally go through that list, article by article, allegation by allegation, and ask, so this article says you were described as Epstein's wingman. Is that true or false? This article describes your relationship as a so-called bromance. Is that accurate? This article references specific events you attended together. Did those events occur? One after another for hours. And Trump either confirms the reporting, which destroys his defamation claim, or he denies things under oath that can be independently verified, which creates a whole different set of legal problems. Let's talk about the underlying factual problem with Trump's case, because this is the part that makes the whole lawsuit almost surreal. After Trump filed his initial complaint claiming the birthday letter was fabricated, the Epstein estate produced the actual 50th birthday book. Not just the single letter, but the entire book, with pages from multiple people collected by Ghislaine Maxwell. And right there in the middle, exactly where you'd expect it to be in alphabetical or chronological order, is Trump's entry. Handwriting analysis has been conducted. The provenance of the document has been established. The evidence overwhelmingly indicates this is exactly what it appears to be: a genuine contribution from Donald Trump to Jeffrey Epstein's birthday celebration. So Trump is pursuing a defamation case where the central claim that the document is fake appears to be provably false. He's not just failing to meet the actual malice standard, he's suing over reporting that, by all available evidence, is accurate. And in defamation law, truth is an absolute defense. If the Wall Street Journal reported something true, it doesn't matter if they did it with the worst intentions in the world. Truth kills the case completely. The really fascinating strategic question here is why the Wall Street Journal might not take the most aggressive approach available to them. There's a school of thought, and some very sharp legal minds subscribe to it, that says the best response to a Trump lawsuit isn't to file a motion to dismiss. The best response is to answer the complaint, accept the fight, and immediately go on the offensive with discovery. Skip the procedural arguments. Don't give him the delay of motion practice. Just say, great, let's go to trial. But first, let's schedule your deposition. There's actually a perfect case study for this approach, and ironically, it involves someone from Trump's own inner circle. A few years back, Trump sued his former attorney, Michael Cohen. Cohen's response was brilliant in its simplicity. He demanded Trump's deposition. When the court agreed Trump had to sit, Trump suddenly started getting very uncomfortable. He asked for extensions, delays, scheduling conflicts. The judge accommodated some of these requests, but eventually drew a line. Show up for your deposition or this case gets dismissed. And what happened? Trump waited until literally hours before the scheduled deposition, with Cohen ready and waiting, and dismissed his own case. He ran. He took the exit rather than face questions under oath. That's the playbook. That's the precedent. And it's even more powerful in this Epstein-related case because the subject matter is so much more damaging. The birthday card case isn't just about whether Trump wrote a note. It's about the nature and depth of his relationship with one of the most notorious figures in modern history. Every question opens another door. Trump doesn't want opened. Every answer creates more exposure. Every hour in that deposition chair is an hour where the walls close in tighter. The judge who dismissed the initial complaint actually did Trump an enormous favor, whether he recognizes it or not. The dismissal gave Trump a graceful exit. He could have walked away, spun it however he wanted, said the court found a technical issue, said he'd made his point, and moved on. Nobody would have been able to force him to sit for a deposition about Epstein because the case would have been over. Instead, he's choosing to refile. He's choosing to walk back into the arena where all of this gets exposed. He's choosing to create the exact legal mechanism that could force him, under oath, to answer 7 hours of questions about Jeffrey Epstein, about birthday cards, about secrets, about the nature of their relationship, about everything. There's an old legal saying about the rule of holes. When you find yourself in one, stop digging. But some people, when they find themselves in a hole, grab a bigger shovel and start digging faster. That appears to be exactly what's happening here. The legal community is watching this unfold with a mixture of fascination and disbelief. The factual foundation of the case appears to undermine Trump's own claims. The discovery process would be devastating. The deposition alone could produce headlines for weeks. And all of it, every single bit of it, was initiated by Trump himself. Nobody dragged him into court. Nobody forced his hand. He chose this fight, and the fight may end up revealing far more than he ever intended. Whether this case proceeds to discovery, or whether Trump ultimately does what he did in the Cohen lawsuit and bails at the last possible second remains to be seen. But the trap is set. The mechanism is in motion, and the only person who put it in motion is the person sitting right in the middle of it. That's it for today, folks. See you in the next video.